6 constituencies that have come to the Supreme Court, 4 of them have been declared null and void. Of course, the court is asking that they have to go back, and then the orders of the court has been nullified. So you can see some party faithful jubilating over there in all of that. So basically the Supreme Court has spoken, and then the parties will have to come back again on the Tuesday, the 1st of December, for a decision to be taken in relation to the mandate. So I have Dr. Justice Srem Sai, who has also been at the Supreme Court. Just help us understand what the decision of the Supreme Court is really to the already declared seat. The court is saying that in respect of 4 out of 6, the order has been quashed. What does it mean?
Yes, so you would recall that in the facts, 2 of the constituencies had not yet been declared, and 4 of them were declared. So the court's ruling is that those 4 that were not declared, the order was quashed in respect of them. And what it means is that there is no order for recollation as we described it in the case. And so the court's further direction is that those cases are supposed to continue. And as you can see, the point we have always been making has been that no court really has jurisdiction to refuse to hear a person who is an interested party or who's in respect of whom an order will be affected. So to the extent that the court expressly refused to accept these people, to hear them, is a fundamental flaw in the whole case. And so the court went further to take the case from the judge, basically saying that what you did shouldn't be done, and we want people to have confidence in the judiciary. So even though we are not saying that you have done anything untoward, what we are saying is that we want people to feel that they are being heard. And that is why they moved the case from that judge, and the case will be assigned to a different judge to hear the matter.
So with those parliamentary candidates, those who were affected, specifically with the NDC candidate, what should they be thinking right now? Are they winners as had been declared earlier by the EC?
No, as far as our position is concerned, and the position, once the order is quashed, we revert to the status quo ante, which is what used to be before the order of 20th December. So what it means is that they had already been declared, and the argument that the EC had been making that they would redeclare, now that case will be heard on the merits, whether there should be a redeclaration, as we call it, a recollation, because our position has always been, and that is the point of conflict. While the MPP guys are saying that they don't believe the results could be collated and recollated and the EC can correct its own mistake, we are of the view that once results have been declared, and the EC has been, abiding by this principle for some time. And once the result has been declared, the only way you can challenge it is when it's gazetted and then you file a petition. That has been our point. So now I believe that will be the argument before the court, whether or not there should be an order of recollation.